Masters of Education 571 for St. Martin's University, Summer Quarter, 2010. This short video will introduce you to the areas of contracts and civil procedure discussed in the first week's readings, chapters 1 and 2. Let me first point your attention to the two assignments. Everyone is required to collect, compare, and contrast teacher contracts. And the second assignment for Masters of Education students is to review the criteria for submitting articles to the Journal of Educational Controversy. With respect to these two chapters, the important thing to remember at the outset is that in the United States we have a dual system of law and of civil procedure. With respect to the sources of law and the hierarchy of law, there are obviously constitutions, statutes, administrative regulations, and what's called common law. So, for example, we have the United States Constitution, and we have every state has a constitution. Constitutions are structured like a business. They have three branches: legislative, executive, and judicial. And the constitutions have a Bill of Rights or Declaration of Rights, which protect citizens from what's referred to as state action. This is an important concept to remember because it applies to the rights teachers have whether they're in a public school or in a private school. If you're in a public school, state action is presumed and teach greater rights to free speech, etc., than in a private. Generally speaking, in a private school, teachers do not have constitutional rights. Concept to remember under the Constitution is that federal law generally is supreme as long as the federal government, in particular, is acting within one of its enumerated powers. For example, Congress has the power to regulate interstate commerce, and says congressional enactments are tied to that power. The federal law will be supreme over state laws. You'll note that the 10th Amendment to the U.S. Constitution leaves everything else to the state and to the citizens. Now, the states have broad powers for those powers that are left to the states, and this is called police power. The state can enact laws that for the public peace, health, and safety. With respect to statutes, the state's statutes are found in the U.S. Code. The state statutes are found in various state codes. In the state of Washington, it's referred to as the Revised Code of Washington. Likewise, administrative actions at federal level are referred to CFRs, or Code of Federal Regulations, and on the state level, in Washington, we refer to them as WACs, Washington Administrative. Now, with respect to the common law, this is court-made decisions, either on the or state level. Federal common law limited to specific areas where the federal government specifically enumerated powers, such as for bankruptcy, interstate commerce, civil rights, and antitrust. The states have far broader common law authority, and this is the primary source of law for what's referred to as torts and contract law. We'll study torts in week 3 in chapters 5 and 6, but there are basically two types of torts: intentional and negligent actions. Contract is a topic in these first two chapters. Understand that a contract requires 4 basic elements. You have agreement, which is defined as an offer and acceptance. It's best to think of that as a minds, that there are definite terms, so there's an understanding of what you're getting into. The second element is consideration. This is normally money or forbearance. You gave up something in part of a bargain for exchange that makes up the agreement. Next, you have to have capacity. Normally this refers to age or mental health, but also for teachers refers to the who has the authority to execute the contract or offer the contract. As an aside, let me make this clear. Contracts are valid whether they're oral or written. Contract in writing under what's referred to as the statute of frauds, but those are fairly narrow areas. Like anything with real estate, has to be in writing to be enforceable. Any contract that performed within 1 year needs to be in writing to be enforceable as a contract. Those are the thing to remember is oral contracts are, even if you have an enforceable contract, there are some remedies. The fourth and final element of a contract is legality. Obviously, a contract cannot violate a specific law or violate public policy. Now, if you have an enforceable contract and there's a breach, your book in these first two chapters refers to certain remedies. They're basically divided into two categories, and they come under a lot of different categories: compensatory damages, liquidated damages, etc. The other general area of remedies is called equitable remedies, and those include things like injunctions, specific performance, etc. Next, let me talk about the dual court systems. Just as we discussed the dual sources of law, there are federal and state court systems. Those are dependent on this term jurisdiction. Jurisdiction means the power of the court to adjudicate a specific dispute and the power of the court over specific persons, whether they are individuals or corporations. Jurisdiction will tell you what court to go to, what level of court to go to. Venue is another word which will tell you within that level or type of court where would you go to. For example, if you had a federal case and you had jurisdiction in the federal courts, both two types, you have to have a federal question, which means either federal constitutional issue or federal law, and the other way you get into federal courts called diversity, where you have people in different states and over 75,000 in dispute. Let's say you have a federal case. The question is, where would you file that case? In Western District of Washington, Eastern, whatever. And that's the issue of venue, and it normally depends on where the defendant is. Both the federal and state court systems have parallel structures. The lowest level of courts are called courts of limited jurisdiction in the federal system. For example, bankruptcy courts are such courts. In the state system, it's small claims courts and municipal courts and county district courts. Then you have courts of general jurisdiction, and these are where most of the action takes place. Federal system, they use district court, which is somewhat confusing because you have county district courts, but federal district courts are where the trials happen, etc. In the state system, states use different names. In our state, we refer to the court of general jurisdiction as superior court. Then you have one right to appeal, and there are two levels, but you only have one right to appeal. Typically, appeals go to the next level up. In the federal system, it's called the circuit courts. State system, it's called courts of appeals. You can remember about any appeal is the appellate courts take no new testimony. They are typically locked into whatever the record you made at the court of general jurisdiction, at the trial court. The second level of appeal is obviously the Supreme Court. You have the federal and state Supreme Courts. Now, you don't have a right to go to the Supreme Court, typically. The right to go to the Supreme Court is discretionary by the court. Briefly summarize the civil process so you're aware of it. The way a civil case starts is by filing or service of a summons and complaint. The complaint sets forth your grievance. The defendant can answer that. They can also countersue you, what's called a counterclaim. They can bring in other parties, which is called a cross-claim. Then the other party gets the opportunity to reply. There are motions and what's called re-pract. This includes things like depositions, interrogatories, which is the parties exchange, etc. Then there
You get more motions. The key motions are motions to dismiss, a motion for summary judgment, which, as the name would suggest, is to avoid trial, to have a summary resolution where there are no facts, material facts in dispute, and the law is what is only, the question is how the law applies to these facts. Then obviously you have a trial. It can be a bench trial, meaning by the trial. After the trial, there can be post-trial motions, and then you can certainly appeal. Obviously, A very long, expensive, stressful process. You want to avoid civil litigation if you can.
Therefore, the last thing I want to talk about very briefly is what's referred to as alternative dispute resolution. These are things like mediation, arbitration, that are fairly common now in contract clauses.